Hello, everyone. My name's Shazia Khan. The unit we'll be doing today is 3.27, which is the English legal system. And we'll be looking at learning outcome 3 today, which is to know the organisation and the work of the English courts. Firstly, we'll just summarise in the last session what we did, which was learning outcome 2, which was to understand the rules of statutory interpretation. So we identified what statutory interpretation was and identified why it's so important in regards to the legislation and how something is conveyed as well. We also looked at the rules of statutory interpretation. We looked at the literal rule, the golden rule, the mischief rule, and the judge's discretion. We looked at what the literal rule was and how the judges consider this when looking at a case, and what the legislation actually says rather than what it actually means. We also looked at cases in regards to the literal rule, called the case of Fisher and Bell, 1960, which looked at displaying a flick knife. We then went on to look at the golden rule, and we looked at the fact that the golden rule was a modification of the literal rule, and it looks at if the literal rule produces any sort of absurdities or anything, then the court should look for another meaning of the words to avoid that absurd result. And that was looked at. We looked at the case of Alder and George, 1964, which looked at the issue of to try and, in this case, the rule was used in this case to avoid any sort of absurd results. We then went on to look at the mischief rule, which gives more discretion to judges than the literal or the golden rule, and this requires courts to look at what the law was before the legislation. We looked at the case of Cockery and Carpenter. And then finally, the rule that we looked at was the judge's discretion. And here, judges have the discretion to apply any of these rules of statutory interpretation as they deem appropriate. So each of the rules has its imperfections, but it provides judges with the ability to interpret legislation in the best way possible to achieve the result as intended by Parliament when the law was enacted. We then went on in learning outcome 2 to look at intrinsic and extrinsic aids in statutory interpretation, and why these are needed when judges make decisions. And also we looked at examples of intrinsic aids such as long title to the Act, the preamble, interpretation schedules, etc. We then went on to extrinsic aids and looked at things like explanatory notes, previous statutes, dictionaries, and what the meaning of the words actually mean. And we looked at advantages and disadvantages of intrinsic aids. Now we are going on to look at learning outcome 3, which is to know the organisation and the work of English courts. So the learning outcomes here is to describe the court hierarchy for both criminal and civil law and explain the process of appeals. So 3.1 is to describe the court hierarchy for both criminal and civil law. And what I'm going to start off with is a short video on regards to the UK court system, explained briefly in the UK. This video looks at the UK court system explained and how it works.
Let's move on to the United Kingdom's court system. What you see here is a simplified overview of the main courts and their hierarchies. The details of how which court hears which cases and appeals are far more complex. But for now, let's focus on the basic structure. We will direct you to resources with additional information at the end of this lesson. At the very top of the court structure sits the United Kingdom Supreme Court, previously called the House of Lords. Below the Supreme Court are the so-called Senior Courts of England and Wales, the Court of Appeal, and the High Court. The Senior Court hears cases that are serious or raise important issues. The Court of Appeal hears appeals in criminal and civil matters against decisions made in a county court, in the High Court, and the Crown Court. The High Court functions as both a court of first instance for high-value civil claims and as an appellate court for civil and criminal cases. It consists of 3 divisions: the Queen's Bench, the Chancery Division, and the Family Division. Below the senior courts is the Crown Court. This court sits in various centres throughout England and Wales. It deals with criminal law cases. Below the Crown Court is the Magistrates' Court, which is also found throughout the country. The Magistrates' Court mainly hears criminal law cases. For civil law matters at the lower level, there are county courts, which deal with civil law matters, as well as family courts for family law issues. Finally, there are various tribunals that deal with specialist issues, such as tax, employment, and others. This is the UK Supreme Court, located in Westminster in London. At the Supreme Court, cases are heard either by 5, 7, or 9 of the 12 justices of the Supreme Court, each of whom reaches an individual decision. Their overall verdict is achieved either by unanimity or at least a simple majority. The UK Supreme Court is the final court of appeal in the United Kingdom. Like its US counterpart, the UK Supreme Court only hears appeals for certain cases. These cases must include arguable points of law that are of the greatest public importance. In civil law cases, the Supreme Court is responsible for hearing cases for the entire United Kingdom. In criminal cases, it hears cases for England, Wales, and Northern Ireland, but not for Scotland.
So we can actually see from that video that I identified the different types of courts in the UK, and the highest court being the Supreme Court. So it just gives you an idea of which courts we will be going through for both criminal and civil matters. So the hierarchy for civil law is that the hierarchy for civil courts in England, as mentioned in the video, the Supreme Court of the UK, the Court of Appeal, the High Court. Within the High Court, there's the Queen's Bench Division, the Family Division, the Chancery Division, County Courts, and the Tribunals. The whole point of having this hierarchy of courts and why it's so important is that the doctrine of precedent cannot operate effectively without a court hierarchy. Under this doctrine, rulings on new matters from superior courts are binding on lower courts in the hierarchy. This ensures, the whole point of this is that it ensures that the law is consistently applied. So the Supreme Court, this is the higher most body of civil judiciary in the United Kingdom, of criminal judiciary in England, Wales, and Northern Ireland. It is the Court of Final Appeals when it comes to civil cases in England and Wales. The Supreme Court is a final court, as I've mentioned, for civil cases, and hears appeals on arguably points of law of general public importance and concentrates on cases of the greatest public constitutional importance. The Court of Appeal, the court actually plays an important role in interpreting and applying the law of the UK's 3 territorial jurisdictions. The next one is the Court of Appeal. There are 2 divisions, as mentioned earlier, in the Court of Appeal, the Criminal Division and the Civil Division. The Civil Division of the Court of Appeal hears the appeals from the High Court, the tribunals, and under certain circumstances from county courts. The decisions by Court of Appeals are binding on itself and all other courts, excluding the Supreme Court. The Court of Appeal is the 2nd most senior court in England and Wales, and they are based in the Royal Courts in London. Cases are heard by Lord or Lady Justice of Appeal, in some cases, High Court judges. The next one that we're going to look at is the High Court. There are 3 divisions within the High Court, namely the Queen's Bench Division. This division handles all the cases relating to contracts and tort in the region. The court segments that fall under this division include Commercial Court, Mercantile Court, Admiralty Court, and Technology and Construction Court, and Administrative Court. Then we have the Family Division. This division houses the Company Court, Divisional Court, and the Patents Court. And then the Chancery Division, this division houses the court which handles all the issues regarding family law, matrimony, etc. The decisions of the divisions of the High Court, though binding, can be appealed to Civil Division of the Court of Appeal. The High Court is bound by the doctrine of precedent by the decision of all courts above, such as the Supreme Court or the Court of Appeal. Any appeal from the decision of the High Court judge is made to the Court of Appeal and then to the Supreme Court. In turn, the High Court's decision bind the lower court's decisions. High Court judges do not follow each other's decision, although previous High Court authority is deemed as highly persuasive, and they therefore usually do so. Then we've got the county courts. The jurisdiction of these courts is purely civil, and sittings of these courts in 92 towns, cities across all of England and Wales. The county courts handle almost all of the litigations and cases relating to civil cases. The judges that preside over the cases under the county courts include district or circuit judge. The county court deals with all except the most complicated and the more simple civil cases, such as claims for repayment of debts, breach of contract involving goods or property, personal injury, family issues, including things like adoption and divorce, housing issues, including recovery of mortgage and rent arrears, and repossession. Then we've got the tribunals, and as the video stated, that the tribunals are a specialist court in regards to how decisions are made on specialist areas. There are many specialist areas of law and cases such as immigration, employment, child welfare, which are governed by the tribunals in England and Wales. They are separate tribunals for separate areas all across the UK. And a very popular tribunal is the Employment Tribunal, and that deals with things like if someone is unfairly dismissed, or if there've been any sort of breach or discrimination, then this would fall within the tribunal. So the hierarchy of courts. So you've got at the top, as we mentioned, the Supreme Court, the House of Lords, the Appellate Committee, Lords of Appeal in ordinary or law lords. Then we've got the Divisional Court of the Queen's Bench, Lord Chief Justice and the judges of the Queen's Bench. Then you've got the Magistrates Court at the bottom. Then on the other side, you've got the Court of Appeal, which is the Lord Chief Justice, Lords Justice of Appeal and High Court judges. And then you've got the Crown Court, Queen's Bench and Circuit judges, recorders and justices of the peace, which follows on to the Magistrates Court. So hierarchy of criminal law. So we looked at the civil side, now we're looking at the criminal side. The Supreme Court. So the Supreme Court is the final court of appeal in the UK. It hears appeals on arguably points of law of public importance for the whole of the UK in civil cases and for England and Wales and Northern Ireland in criminal cases. The Judicial Committee of the Privy Council, which comprises justices of the Supreme Court and some senior Commonwealth judges, is the final court of appeal for a number of Commonwealth countries, as well as the UK's overseas territories, crown dependencies and military sovereign bases. Then we've got the Court of Appeal. The Court of Appeal and the High Court constitute the senior courts of England and Wales. The Court of Appeal is an appellate court and is divided into two divisions, criminal division and the civil division. So the criminal division decides appeals from the Crown Court and from courts martial. Within the criminal division, courts are constituted by the Lord Chief Justice, Lord and Lady Justices, and usually two High Court judges. Leave to appeal is required. The Court of Appeal typically does not receive fresh evidence, but it has the discretion to do so if necessary or expedite in interest of justice. The court may uphold or reverse a lower court's decision, but it may not grant a more severe sentence than originally imposed, except in cases specifically referred to it by the Attorney General in which the trial judge appears to have been unduly lenient. The criminal division also acts as an advisory body on points of law from the Attorney General. So the Crown Court, and this is in regards to criminal law. So the Crown Court sits in centres around England and Wales. This deals with indictable criminal offences, cases that are transferred from Magistrates' Court, including serious criminal cases. Criminal cases are tried in two different courts, as we mentioned earlier as well, the Magistrates and the Crown Court. The Crown Courts were established in January 1972 and are located, as mentioned, regionally. The Crown Court hears cases that are sent by the Magistrates' Court, either at first instance or at appeal. If a case has to go to the Crown Court, it will all depend on the type of offence with which you've been charged. So criminal offences are classified in three types: summary only offences, which can only be tried in the Magistrates' Court. So these are things that are minor offences. Either way offences, which can be tried in Magistrates' Court or the Crown Court, and indictable only offences, which can be tried in Crown Court. And these are more severe offences. So we're just going to go on to look at magistrates' courts. These courts hear all criminal cases at first instance. Less serious cases, as those involving juveniles, are tried in magistrates' courts, as well as some civil cases. Magistrates' courts deal with three kinds of offences, as I've just mentioned: summary, either way offences. Summary offences are the less serious offences. Then either way offences, cases that can be heard, as I mentioned earlier, both in Magistrates' Court or before a judge in the Crown Court and a jury, and then indictable only offences, and these are more serious offences. The Magistrates' Court is the lower criminal court in UK. There are about 330 Magistrates' Court in the UK, with one in almost every town and city. For the most part, magistrates, as we mentioned, try criminal cases in the Magistrates' Court, with 90% of criminal cases being completed there. Magistrates may be either unqualified justices of peace or qualified district judges who deal with longer, more complex matters that come before the Magistrates' Court. Each Magistrates' Court also has a legally qualified clerk present to assist the magistrates on legal matters. Okay, so now we're going to go on to 3.2, which is looking at the process of appeals in the UK. So in the appeals process, the Court of Appeal, in most cases, permission to appeal to the Court of Appeal is required. One has to lodge an appellant's notice within 21 days of the decision to be appealed, along with the grounds of appeal. Full documentation and a skeleton argument in support have to be provided shortly after that. If permission is granted, the appeal will be heard, usually before a 3-person court. Usually no evidence is allowed, as the facts have been available at the High Court stage, but sometimes it is possible to file fresh evidence. As in the High Court, the judgment may be given on the spot, though usually it is handed down. Appeals, as we've said, are decided by panels of 3 judges working together. The appellate presents legal arguments to the panel in writing, in a brief form, and then in the brief the appellant tries to persuade the judges that the trial court made an error and that its decision should be reversed. The court determining an appeal will correct errors by trial judge, and the right of appeal ensures that as far as possible courts will arrive at a correct decision. The decisions of the appellate courts are fully reasoned, widely available, and they do not always pull their punches. In most cases, permission to appeal to the Court of Appeal is required. The lower court may grant permission, but this is unusual, as it is a way of saying that the judge accepts the decision may not be right. More often, permission is refused, and one has to apply for permission from the Court of Appeal itself. It is vital to initiate the process quickly. As we've mentioned earlier, one has to lodge an appellant's notice within 21 days. If permission to appeal is refused at that stage, that is the end of the matter. One cannot take it further to the Supreme Court and will have been refused twice in the High Court and the Court of Appeal. And if like we said earlier, if the appeal is granted, it's heard between the 3 judges, and then they will base their facts and allow a brief and a skeleton argument, then identify whether there is the appeal is allowed. The appeals process at Supreme Court. So a dissenting judgment in the Court of Appeal could be a good route to getting permission to appeal to the Supreme Court from the Court of Appeal direct. An appeals committee of 3 Supreme Court justices will decide whether to grant permission or to appeal or not. Permission is given extremely sparingly, usually in relation to cases involving important points of law. Usually it is necessary to apply to the Supreme Court for permission to appeal. An appeals committee of 3 Supreme Court judges, as we've just mentioned, will either give you permission to allow the appeal or not. The other parties may be asked to provide observations before the appeals committee makes up its mind. If undecided, it can order a short oral hearing. If permission is granted, the procedure in the Supreme Court is elaborate and can be relatively expensive. But if you are the appellant, you are lucky to be there. There are several cases that go to the Supreme Court. The CPRE Kent case against Dover case, which established the principles of the duty to give reasons in planning decision making, and the Laypole Bank case was referred by the House of Lords to the Court of Justice of the European Union, which found in our favour. Similarly, the Barker case concerning the old Crystal Palace site, which together with Wells is of great importance, of the application of environmental impact assessment, EIA. Another really important case in regards to that is the case of Mellor, which was very important for clarifying the reason required when public authorities do not require EIA, and by extension, it is good for reasoning and accountability. So we'll just, so we finished this session, and we need to mention to summarize and conclude at the end of it that we need this hierarchy of courts, both for civil and for criminal law. And the reasoning behind it is that without having the doctrine of precedent, as mentioned earlier, cannot operate effectively if there was no court hierarchy in place. And, you know, we need to look at the superior courts, that their decisions and their rulings are binding on lower courts. And the whole point of it is that we try to establish that the law throughout in any court is consistent and it is applied, and the laws passed by Parliament are applied in these courts, and judges interpret these laws to each individual case. So some of the references are just here: public law, European law, Hart Publishing, principles of criminal law, and interpreting precedents. Some more references just there as well. In regards to any sort of additional information or anything, please use Moodle as your main resource for trying to get any sort of additional information, any case law that will help you towards completing your assignment part on Learning Outcome 3. So now we've finished Learning Outcome 3, the next session will be to do with Learning Outcome 4. Thank you for attending today's session.